This is the Landlord Advocates, where we help landlords become better landlords. I'm your host, Matthew Lyman. Welcome back. In our last video, we analyzed various lawsuits that have been filed from coast to coast against various governments, state and local, regarding these eviction moratoriums and the impact that they're having on landlords. The one case that we alluded to in that video was filed in New York State, U.S. District Court, Southern District, on May 27, 2020. We're not going to go over that case specific because you can go back on our latest video and watch that. It's towards the latter part of the video, and you'll see the meat and potatoes of that lawsuit. Well, on June 29, 2020, the judge in the case, Colleen McMahon, rendered her decision in this case. And we're going to tell you that decision now. But before we do, we want to go over how we're going to do the format of this video with you. Her decision was 37 pages long. We absolutely are not going to recite 37 pages of her decision. Instead, what we're going to do is we're going to read excerpts of her decision. And then we're going to put the landlord's perspective and how we feel in regards to the decision that she rendered, whether it was good or bad for us. We're going to let you know. And we're going to explain to her, as well as everybody else who's watching this video, how the landlords feel. The decision of the judge is this. She has summarily dismissed all aspects of this lawsuit against Governor Andrew Cuomo of the state of New York. The lawsuit was brought by three petitioners, three plaintiffs. Abbotsford Apartment Associates, LLC, 36 Apartment Associates, LLC, and 66 Apartment Associates, JV. The first few pages of her decision are just the fluff. It goes over the lawsuit, the COVID-19 crisis, what the state legislature and Governor Cuomo did in regards to that. We don't need to go over that. We all know about that. We just want to go into her decision and how she came to the decision to dismiss all aspects of this lawsuit. She went on in Parliament to show the Executive Order 202-28 that was initiated by Cuomo on May 7, 2020. And the administrative court and the decisions that they have rendered as far as evictions and how they're going to be handled. And the chief administrative judge is Lawrence Marks. And he goes on to state that evictions can be filed electronically or via the mail, no in person, but they can be filed. But before they do, the landlord or the landlord's attorney must file an affidavit, the landlord, or the attorney's affirmation, the attorney, attesting that the tenant is not on unemployment, eligible for unemployment, or facing a financial hardship. If the affidavit or the affirmation attests to that and say, no, they're not, then the landlord, via the attorney, can file the case in court to be heard whenever that may be. They can also do that with the holdover cases where rent is not an issue. But there's a caveat to that. And this is where we're going to start reading excerpts. The administrative order only allows the action to be filed. It cannot proceed to trial so long as state and federal emergency measures addressing the COVID-19 pandemic remain in place. All RPAPL, that's Real Property and Procedures Law, eviction matters, new or old, shall continue to be suspended, although parties represented by counsel may schedule virtual, judicially supervised settlement conferences. Now, so this says that you can file them, but who knows how long they will take to be heard. It also states that the landlord has to have counsel. the tenant has to have counsel. That means an attorney. Evictions have been known for many landlords to be able to go to court and argue the case on your own behalf. That's called pro se. You don't need a lawyer. Now they're saying you do. Well, lawyers, attorneys don't work for free. Attorneys in our firm do not work for free. They need to get paid. So here you're put in a position where you have to hire a lawyer to represent you in these virtual, judicially supervised settlement conferences. Now here's the irony behind that. If there's no kumbaya agreement between the two lawyers, then the case goes to trial, but it's not going to happen. So when will the end, when will the adjudication in this case actually happen? Who knows? Do they really believe that the attorney for the tenant is going to agree to a warrant of eviction to get the tenant out of the property? Absolutely not. They're not going to agree to that. So either the landlord, through their attorney, gives into every concession that the tenant's attorney may offer, or they're going to say, we want a trial. We're going to ask for a trial. Therefore, it suspends that settlement conference. Again, we're not going to read what the motions were in this case. Go back to the previous video and watch that, and you'll see what the motions were. Governor Cuomo, in his defense of this lawsuit and his Executive Order 202-28, says that executive order neither robs the plaintiffs of the entire value of their property interests, nor does it bar them from vindicating those interests to the fullest extent provided by lease and by law once the current health crisis has abated. It neither robs the plaintiffs of the entire value of their property. Well, the plaintiff, the landlord, the entire value of their property is where they're making money off the tenant residing in the dwelling. So when you talk about the outside of the 100% value of the property, well, they're not talking about the backyard. They're not talking about the front yard. They're not talking about the driveway. They're making their money off the rental of the apartments. Not so much the backyard, the front yard, the driveway. They're not. There was a brief filed by the Mount Vernon United Tenants and the United Tenants of Albany in support of the eviction moratorium. And part of their defense or their agreement of the eviction moratorium goes as such, that it would require tenants, if the eviction moratorium was lifted, it would require tenants to make impossible choices between their health and the community's health and their homes. Right. Let's analyze that for a second, okay? Yes, we want tenants to feel that this is their home and to treat it as such. But the blunt aspect of it is that it is not their home. It is not their home. It is their dwelling that they get to have by paying on a 30 or 31 day cycle a certain amount of money to the owner of that home or property, apartment complex, whatever you want to call it, to utilize that same space on a 30 or 31 day cycle. If they're not paying for it, then they need to leave. And that's why the landlords want to do the evictions, if they're not paying for it. It says that if they want to be put out, it puts a risk further spread of the COVID-19. It spreads it further, the risk. Okay, that's hogwash. Why is it hogwash? Because think of it, my friends, think of it. How many of these people who are in jeopardy of being evicted have actually self-quarantined the entire time during this crisis? How many of them have stayed in their apartments, disassociated themselves, physical contact with other human beings during this whole crisis? If they have not, if they go to the Walmart, the Price Chopper, the Walgreens, the Costco, and they've interacted with other people that they have potentially spread the COVID-19 crisis, or the pandemic. They've actually spread it. Possibly. But to say that to evict them will cause the spread of that, they may have already done so by going to the grocery store. They said that it would cause extreme stress and overcrowding in the housing courts, the eviction court, summary proceeding court, whatever your court may call it, and then to cram people into the housing court, further exacerbating the current public health emergency. No, it would not. No, it would not, for a few reasons. The courts are large enough to where they can have hearings, 3 or 4 in the courtroom, and keep the people spread out far enough. They're not going to be like listening to be spread them out further, they can do that. And hear cases not just for 2 hours a day, have cases all day long. So you might have 4 or 5 per hour. So you can, in essence, listen to 25 cases, 30 cases per day. Just spread them out, you can do that. And here is another little tidbit that we're going to add into this video, even though we're also going to really expand upon it in our next video, is that if they're talking about housing courts and cramming people in, can you explain, judges, courts, can you explain to us landlords why criminal courts, county courts, police courts are open right now across the state for in-person appearances? Why is that? Let's look at rent not being paid. Let's equate that to petty larceny, grand larceny, theft of services. Is that not what is happening to landlords when a tenant doesn't pay rent? Are they not stealing from the landlord? In civil court, they don't call it stealing, they call it a debt that the tenant will owe you in the form of a judgment. But on the criminal side, it would be the same thing. So if somebody goes into a Walmart and steals a $50 pair of headphones, they can go to jail for petty larceny. They can be arrested for it, rather, and they go in front of a judge, and they answer the charge of petty larceny. Well, what if a tenant was $10,000 in back rent? Why can't they be brought before a judge and say, listen, judge, they stole the dwelling by not paying for it, and we need to recover that. Recover the headphones, and then we can put them back on the shelf to sell them to make a profit. That's what we're here for. That's why Walmart is here. That's why landlords are here. To put their apartment on the market to make a profit from that. She claims that this court does not have jurisdiction to enjoin purported violations of the executive law or the New York State Constitution. Meaning that this lawsuit had mentioned state constitution violations as well as federal constitution violations. Judge, would it not have been possible to remove the state constitution aspects of this lawsuit and just look solely on federal constitution violations? Could you have been able to do that? She claims that federal courts do not have the power to address claims that Governor Cuomo has violated state law. While it may be the case that Governor has overstepped his authority under New York's executive law, that to require the court to ignore the doctrine of state sovereign immunity and principles of federalism is mandated. So she admits that he may have overstepped, but they can't really address that because it's a state doctrine, not a federal doctrine. And she states that the Supreme Court ruled that federal courts could not grant relief against state officials for their purported violations of state law. Now, one of the aspects of this lawsuit was about the takings, where the government takes the property from the landlord for a duration of time. She cites 2 different forms of takings. One is physical takings and regulatory takings. We're going to address the physical takings aspect first, as she did in her answer to this lawsuit. The plaintiff fails to demonstrate that the order causes them to suffer either type of taking. She goes on that the government affects a physical taking only where it requires the landowner to submit to the physical occupation of the land. Isn't that what's going on here? You're submitting to the occupation of this land by a tenant. No, they're saying that the government themselves are not there? That Governor Cuomo is not living in this house? Or Assembly Speaker Paul Hasty is not living in my home? I can't say, hey, pass the butter, pass the salt, and they're not actually living here? That's a play on words here. The apartments are still occupied by tenants when the landlord doesn't want them. And the government says, well, you have to keep them there for a duration of time when we decide that it's okay for you to take them to court. Government actions that does not entail a physical occupation, but merely affects the use and value of private property, does not result in a physical taking of property. Again, the government is not physically occupying the property, but when you affect the use and value of that property, are you not taking the property from us? Yeah, you're allowing me to keep it, but you're not allowing me to use it. Okay, tell that to a little child that you put in a corner for half an hour for being a bad boy or girl, and you take away that toy that they want so badly. You're going to cry and scream for that toy. You took it away from them. It's theirs, but you took it away. You prohibited their use of that toy for a duration of time. Here, in essence, you've taken away the ability for the landlord to do as they wish to get the tenant off the property so that they can do as they wish with that property. And they've done nothing wrong. There's no reason for them to be put into the corner. The Supreme Court has ruled that a state does not commit a physical taking when it restricts the circumstances which tenants may be evicted. So, in essence, does this mean that the states can enact such restrictions that it basically immobilizes the landlord's ability to evict a tenant? What do they mean by restricts the circumstances? How far can they restrict it? Bowen constrictors restrict the life out of a rat when they're ready to eat it to the point where it dies. Is that the intent of this? Is that what they mean doing to landlords? Is to restrict their ability to do as they wish with their property to the point where their property is valueless to them? She puts it, in her words, bluntly, no government has required any physical invasion of petitioner's property. Petitioners' tenants were invited by petitioners, not forced upon them by the government. Well, yeah, okay, we know that. Does it really have to be stated in here? Yeah, you did not, no government required us to take the tenants. It was a choice that we made. Same thing when you go into a store or a restaurant. Nobody forced, the government didn't force the person into the place. The landlord and restaurateur invited them in to consume a consumable food or an apartment, whatever you want to call it, to be paid for later after consuming that which was offered by the restaurateur, the management of a mall, of a store, or a landlord. Yet they were invited in, but if we don't want them there, we have the ability to call the police and have the person escorted out in that restaurant, that gas station, that convenience store, that Walmart. You can do that. We don't want them there. Please make them leave. Make them go away. Thank you. But a landlord in this order is not allowed to do that. They're being told that you gotta keep them there. So yeah, you may not have forced that person upon us, government. We wanted them in because they met variables that made them look good for us. That they could afford what it is that we offered because they said they could. But now you're telling us, sorry, they may have lied, they may have stopped paying you, but you gotta keep them there. The circuit court said, a physical taking only occurs when the government has committed or authorized a permanent physical occupation of the property. So basically what they're saying here is that because this eviction moratorium is not permanent in nature, permanent by definition, that this eviction moratorium can go on and on and on because it's not taking of the property because it's not permanent. It's just temporary. She also claims that because the landlords failed to show that the executive order denies them control of their property, which they continue to rent to their tenants, and collect rents from a temporary halt on evictions does not take on the character of a physical taking. That's what she claims. So let's break it down. The landlords fail to show that the executive order denies their control of their property. How is that? If a tenant breaks up the place and calls code enforcement, the landlord has to go there and do these repairs. They want the tenant gone. The government says, not right now, later on, but not right now. How is that not taking away control of their property? Because it's not permanent, that's why. Which they continue to rent to their tenants. Well, yeah. But if they're renting, the assumption is that they're being paid. Maybe that's not the case. So you can rent to them, but you're not getting paid. It's a no-win situation for the landlord and collect rents from the tenant. A temporary halt on evictions does not take on the character of a physical taking. We're going to go on later on in the case, just now actually, to show how the government says that this is okay. In the case of Kirsch versus the City of New York from 1995, the same court made a ruling. And it goes something like this. New York State does not violate the Takings Clause when it assumes management of a property from a landlord and rents units therein to parties without the landlord's approval. That is really scary to think that it is not takings when the government can come in and take over management and rent out the property and basically arrest the management or the owner's ability to do as they wish for that property, legally do as they wish for that property, and the government is going to take over that property. In this case here, Kirsch versus the City of New York, it says that they did this because the property had been receiving a number of tenant complaints alleging harassment by the landlord. So here it is, 2020. This was 1995. And in this argument, it says alleged harassment by their landlords. Alleged harassment. So tenants can claim alleged harassment, and the government can come in and overtake that property from the owner. And the lawsuit from Kirsch was that by them doing so, they lowered the rents, then they took monies to fix up the properties, to what degree that may be. Did they replace chrome with beautiful bronze hardware? Did they do that? Did they take out stoves that were and put in stainless steel? So what did they do with the money? And it allowed them to rent out vacant units. They didn't own the property. The state did not own the property, but yet it allowed them to rent out the units to other tenants that may not have been ones that the owner of the property would have wanted on the property. This went on, not for 1, not for 2, not for 3, but for 6 years. For 6 years, this went on in the state of New York in 1995 when the lawsuit was commenced. Maybe it happened in 94 and 93, but in 95 this lawsuit was commenced. They said that it did not permanently extinguish the landlord's property rights, but for 6 years it was okay. So how long does it go on for? Could it go on for 30 years, 40 years, 50 years, 100 years? Permanently. So we know that permanent is a finite number. It's now, it's permanent, it's forever. But in this case here, the 6 years had a dot after it. How much longer could it have gone on for? She goes on to say that the intrusions at issue in this case pose a much shorter and less significant burden to plaintiffs' property rights than those upheld in the Kirsch case. Oh, Judge, with all due respect, and I mean that, is that supposed to make us landlords feel better? Is that supposed to make our people watching this video feel better? Well, that was for 6 years. Yours might only be a year. Don't worry about it. It's only a year. It was 6. You should be thankful. Well, we're not thankful. Why should we have to say, well, they had 6 years and we only have a year, maybe a little more, so shh, we should be thankful. She's saying that there's nothing permanent about the executive order. Well, it may not be permanent, but for the landlords, it ends up hanging them by their fingernails. Well, for them, that's a long, long time for this eviction moratorium to have gone on since March. It may even go on to September, October, November, whoever knows how much longer it can go on for. Maybe even into next year. She said, secondly, the order preserves the plaintiff's rights as property owners to either obtain a warrant for eviction or sue their tenants for back rent. Well, thank you very much. That was our intent in March, with some of the cases that had already been filed to be heard and the tenants were already sued. That is the intent of landlords right now, to file these cases to be heard so that they can get the tenants out for not paying rent or damage on the property. So we know that it can happen, we just want to have it sooner than what you're allowing us to have it happen. And finally, the order neither reduces the amount a tenant must pay the landlord for occupying the apartments. Like, must pay? We would love it if they must have to pay us. And that were the case, we wouldn't worry so much about it, would we? If they must have to pay us. Nor forgives the tenant's rental obligations altogether, thereby allowing them to live on the landlord's property rent-free. Well, what do you think is happening right now? 6, 7, 8, 9 months rent-free. Yeah, we can get a judgment for it later on, but what does that matter? What do you do? Most landlords are not going to collect on that judgment, so they say, well, you get a judgment later on. Well, that's fine. That's fine. But it doesn't mean anything for a lot of landlords. They're never going to see the money. As long as the order is in place, tenants will continue to accrue arrearages, which the landlord will be able to collect with interest once the order has expired. Oh, that sounds so sweet. Sounds so nice. We'll be able to collect later on when the order expires. Oh. Realistically, it's not going to happen. Over the years, there have been millions and millions, even billions of dollars worth of rent not paid to landlords across the United States and Aberdeenshire, all over the planet, who have acquired judgments that they will never, ever see. As to the regulatory taking, she said it does not constitute a regulatory taking. Regulation did not take this property from the landlord. The order is clearly not a categorical regulatory taking, since plaintiffs still enjoy many economic benefits of ownership. What many benefits? Tax write-offs? Maybe. That they had to put $4,000 into the property because it's going to cause damage and they can write off that? Maybe. They can sell the property if they want. Right now, maybe selling's not the best thing because it's a buyer's market, because a lot of people are washing their hair and they want to get rid, wash the properties out of their head. They don't want to be a landlord anymore. So I don't know to the many economic advantages she's referring to. Even under the eviction moratorium, landlords can continue to accept rental payments from tenants not facing financial hardship. There are many tenants out there right now who are not facing a financial hardship. There are many out there who are collecting unemployment in addition to the $600 per week under the CARES Act that takes them until the end of July, and they're still not paying the rent. Many of our process servers have gone out and have been told by the tenants, the governor says we're not paying the rent. We can't get evicted right now. So knowing that, in their minds, there's no repercussions to them not paying the rent. And you know what? They're absolutely correct. There's no repercussions now. There may be later. But most tenants don't think of later. They think of the now. So they aren't paying now. Why worry about it? I don't pay July. I don't pay August. Oh, this is great. This is super. We know a case where a client came into our office yesterday to do an eviction on one of the tenants, and they had mentioned that the tenants across the street had put out in front of the trash, not one, but 2 empty boxes to 75-inch screen televisions. Their tenants across the street as well. Must be damn nice to be able to spend that kind of money on not one but 2 flat-screen 75-inch television sets during an unemployment COVID-19 crisis. Must be really nice. That while also covering the cost of ownership by collecting security deposit funds from consenting tenants who have been affected by the pandemic. Consenting tenants. We would hope that they would consent to pay an obligation that they committed to on their security and on their end. We would hope that they would do that. And if they do, We as landlords do not feel we need to pat them on the back or give them an honor girl or an honor boy for doing what they were obligated to do from the inception of their tenancy on their property. The courts must weigh 3 factors to determine whether the interference with property rises to the level of a taking. One is the economic impact of the regulation. The other is distinct investment-backed expectations. And the other is the character of the government action. The economic impact. Now, the economic impact of EO 202-28 can only qualify as a regulatory taking if it effectively prevents plaintiffs from making any economic use of the property, and that including the portions of the property not subject to restrictions. So any economic use of their property. Okay, they bought the property for people to live there and pay rent. That was the economic use of their property. So when they're saying any economic use, are you suggesting that the landlord set up a lemonade stand in front of the house to hopefully offset the rent that they're not collecting from the inside of the house? Because it says here, any economic use of their property. Do they set up in the backyard a volleyball tournament and charge admission to help offset the money not coming in to pay the expenses of the property, the taxes, the insurance, the upkeep, the mortgage, and any other thing that may pop up that landlords know full well usually pops up? So they'll have a basketball tournament, they may have lemonade stand, who knows what they'll do, since they're not prohibited from any economic loss that they can make up for that some other way. That's how we construe this definition of any economic use of their property, and including the portions of the property not subject to restrictions. Alright, the driveway, the backyard, the front yard, subject to restrictions. Okay, most landlords rent out the property with the use of the driveway for the tenants to be able to use. Well, if they're not getting the rent inside, they don't want the tenants using the driveway and everything else, but they're mandated to do so. Investment-backed expectations. There's a big paragraph here, we're not going to read it. We're going to look at, because landlords understand that the contractual right to collect rent is conditioned on compliance with a variety of state laws, their reasonable investment-backed expectations cannot extend to absolute freedom from public programs adjusting the benefits and burdens of economic life to promote the common good. That's a lot in a mouthful there. What we're saying here is that landlords understand that the contractual right to collect rent is conditioned on compliance with a variety of state laws. Well, they've done that. They have certificate of occupancies. They have rental certificates. They met fire code. They met all of the laws required to allow someone to habitate that property. So now they've done that. They've met the requirements for fire code, smoke detectors, building code. So allow them to make money off the property. New York landlords do not enjoy a constitutional right to realize a profit from their rental properties. Okay, does that really need to be said? Does any landlord or any merchant in the United States believe that they have a constitutional right to profit? Of course not. How many businesses have failed out there? How many have succeeded? Nobody goes into business knowing that they're guaranteed a profit. They're hoping for a profit. They want a profit. So they can get the profit, build more stores, more gas stations, more restaurants, buy more apartment buildings, and employ more people so everybody's making money. That's what their goal is, to make a profit. They know that there's no constitutional right to that. That's what capitalism is all about. That's what the free market is all about. That's what democracy is about. To be able to take the effort, the risk, in order to turn a profit for that risk. Well, here the government is temporarily prohibiting landlords from turning a profit on that property. The order's temporary adjustment of those rules does nothing more than defer the ability of the landlord to collect or obtain a judgment for the full amount of the rent the tenant freely agreed to pay, and it does not disrupt the landlord's investment-backed expectations. how does it not? How does it not disrupt? If we know that the tenant has no ability to pay this rent now, and it's cheaper for them to move at 2 o'clock in the morning, knowing that they owe us $5,000 or $6,000, it's cheaper for them to move out of the property and go someplace else and not pay us the rent that they owe. We know that in their mind that's what they're doing, but they're going to wait until the eviction moratorium is over, that you get them into court, and that the sheriff or marshal comes to throw them off the property. They're going to wait. They've been doing that for years. They know that they don't have to leave until the sheriff or marshal comes to throw them out. So they're occupying their property. The landlord may be able to get a judgment, but it absolutely disrupts their investment-backed expectations. Because the tenant knows that the judgment they're not going to be able to collect on the landlord. They know that the landlord has to take a long time to get them out of the property. So yes, these moratoriums do affect the expectations of the landlord's investment-backed properties. The other one is the character of the government action. The court has considered the extent to which the law undermines the contractual bargain, interferes with the party's reasonable expectations, and prevents the party from safeguarding or reinstating his rights. That's what they're looking at to determine whether or not there's been a violation of the government action. They're just failing to believe that they believe that they cannot have an expectation of rental regulations. Why would a landlord be so concerned about that? Why would a landlord? That's scary to believe that. That plaintiffs cannot reasonably expect to be free of additional rental regulations. They also go on to say, for those who do business in a heavily regulated industry, the expected costs of foreseeable future regulations are already presumed to be priced into the contracts formed under the prior regulations. Let's go over that again. For those who do business in a heavily regulated industry, landlording, construction, restaurant, gasoline, we all know in New York State regulations abound. They abound in many states, if not every one. Regulations are the stranglehold of businesses from coast to coast. But here to say that the expected costs of foreseeable future regulations are already presumed to be priced onto the contracts formed under the prior regulations. So does that go with if a retailer, marketer, has got produce that does not need to be refrigerated out for display and purchase. Now a regulation comes forward, and they priced it based upon that. Now a regulation comes forward and says, now you have to refrigerate all of that produce. So it's presumed that sometime they're going to mandate that the apples and the oranges can be refrigerated. So we have to factor the price for that later on, because the government's going to mandate that. We don't know when, but it will. Same here with the rental outlets. Same here with rents. The same rule applies. We're supposed to presume that more regulations are forthcoming and those regulations are going to cost us more money. We're supposed to presume that? Seriously? That's a scary concept to think that any time the government can do that. More regulations, more fees on you, but that's just the way it is. That's scary, because past regulations puts industry participants on notice that they may face further government intervention in the future. A later in time regulation is less likely to violate the contracts clause, where it covers the same topic and shares the same overt legislative intent to protect the parties protected by the prior regulation. So landlords have to just anticipate that more regulations are coming forward, and they have to factor in the cost that they charge for the product or the apartment solely on the thought that regulations are going to come forward and it's going to cost us a lot more money. That's what they have to do. They go on again that the executive order which modifies aspects of the statutory scheme related to permissible uses of the security deposits should have come as no surprise to the landlord plaintiffs, and thus could not amount to a substantial impairment of their rights under their rental agreement. Furthermore, this is scary, the foreseeability of additional regulation allows states to interfere with both past and future contracts. Furthermore, the foreseeability of additional regulations allows states to interfere with both past and future contracts. Now, what's the purpose of a lease? It's a binding contract between two parties who agree to the stipulations of that contract, that lease. And here you're saying that the state can come in and interfere? I like that word, interfere. That means put your nose in both past and future contracts. Unbelievable that they can do that. Unbelievable that the government can just stick their nose in and interfere whenever they want. That's what it's saying right here. The order preserves that the landlords, the plaintiffs, can ensure that any security deposit used as a payment of rent shall be replenished by the tenant or licensee within 90 days. Judge McMahon, that's not the case. They have to start paying it back 90 days after the utilization of that security deposit. And they have 365 days to pay it back. Well, if they leave the property, the landlord's not going to be able to collect if they leave halfway through. The order does not displace the civil remedies always available to landlords as seeking to recover the costs of repairs or unpaid rents still owed at the end of the lease term or tenancy. Well, of course it doesn't. We can take them to small claims court for the back rent. If they've already moved, we can take them to small claims court for the damages. Of course we can. The landlord can obtain the judgment for the amount expended in the repairs. Now here's where it goes on, where she ends her commentary, which I think landlords are going to have some anger with. And I again emphasize that nothing in the order diminishes the tenant's rental obligation by even a nickel. The landlord can collect all he is owed at the end of the day by the simple expedient of going to some court when the courts are fully reopened. Oh, it's that easy, huh? They can collect all that is owed? Is the court going to render a decision in favor of the landlord and say to the tenant, come here, let me see your wallet. Oh, you have $4,000 in this wallet. You owe the landlord, come here. Here you go. Here's your $4,000. You really think it's that easy to collect? That easily in court? No, it's not. If it were the case, millions and millions of dollars in judgments would not be judgments. They would be satisfied. The fact that landlords would prefer to not avail themselves of their legal remedies because it is often not worth the trouble to pursue a deadbeat tenant does not mean that the state has impaired their contractual rights. For some landlords, it may be worth taking them to court right now when they may owe $400 or $500. The feasibility of collecting that money is more feasible. But when they owe $4,000, $5,000, $6,000 in rent, no. The more they owe, the feasibility of collecting it is less and less and less. And when you even say that it's not worth the trouble to pursue a deadbeat tenant, yeah, you hit that right on the head, Judge. It's not worth it for a lot of these landlords. They're throwing good money after bad. They just walk away from it and say, no, it's not worth it. Take them to court, hire a lawyer, take the time off from work to go out to somebody that's not going to pay. But by letting them stay in the property without getting them out now, exacerbates the problem because the damages in the property could become greater and greater, and the amount of rent due becomes greater and greater as time goes on. The eviction moratorium in Executive Order 202-28 does not violate the Contracts Clause. The Supreme Court has held that a measure altering available remedies without nullifying them either undermines the contractual bargain or prevents the party from safeguarding or reinstating their rights. Again, if it was a permanent executive order, then it would. But it's not permanent. It will end right now as of August 19th, but it could end November 19th, January 19th, February 19th. So there's no permanency to this executive order, so that's why this doesn't apply. The eviction moratorium does not eliminate a suite of contractual remedies available to the plaintiffs. It merely postpones the date at which landlords may commence summary proceedings against their tenants. The tenants are still bound to their contracts, and the landlord may obtain a judgment for unpaid rent if the tenants fail to honor their obligations. Again, the judgment for many landlords is meaningless. They can acquire the judgment, but it doesn't mean anything. They're not going to collect on it. That being so, the implied right to such legal process has not been impaired by the order. That they can go to court, when the courts reopen, and they can petition the court to have the tenant removed. So it has not been impaired for the duration of life, for the duration of the planet, just temporarily. The executive order does not violate the plaintiff's rights under the Due Process Clause. To succeed on a procedural due process claim, it must first identify a property right, that the state has deprived the landlord of that right, and third, shows that the deprivation was effected without due process. To begin with, she says, the plaintiffs have not identified a property interest independent of the interest addressed by their constitutional claims. She says they've already addressed that, you can't do it again, it's duplication, it's forbidden, that's gone. The plaintiffs complain that they'll have to wait before pursuing the remedies otherwise available to them. The executive order does not deprive plaintiffs of their property rights, she goes on, because they have to wait. If they could not do it at all, then it would, but they have to sit there and wait. Therefore, for some reason, for the same reason, the plaintiffs also have to show a denial of due process. They state that first, they can still initiate eviction proceedings against the tenants who are not facing financial hardship, who have chosen not to pay the rent. Well, as we alluded to earlier, they can do that, but if Chief Administrative Judge Lawrence Marks says all of them are on hold, there's going to be no trials, when they can bring it forth via the mail or electronic filing, but it's a dead-end street. You can go 100 miles an hour down that dead-end street by filing all this paperwork and shoving all these notices. But if you don't put the brakes on, baby, you're going off the cliff. You're going off the cliff. So you can file all you want, but if the court's not going to have in-person hearings, and they're not going to have a trial, what is it going to get you? Probably in court after August 19th, August 20th, September, who knows? They mentioned that no case says that a meaningful time means as soon as a cause of action accrues. That in New York, the filing of a summary proceeding is but the first step in what often takes years to accomplish. Well, no, it doesn't take years to accomplish an eviction in New York. But let's go on that premise that it does take years to effectuate that. Let's say it does. If that's the case, then why is there a moratorium even in place? Because if they can file this eviction now, let's do it now, because it's years down the line, 2023, 24, 25. By that time, hopefully the pandemic will be over, and the eviction can go through. It doesn't take years, it takes 2 or 3 months as of prior to COVID-19. So now it might take 4 or 5 months or even longer, as you've seen by the time you get into court. So, a meaningful time. Well, a meaningful time is an abstract term. A meaningful time to a landlord not getting the rent is now. The meaningful time is now. We gotta get them out now. A child playing on the playground, a meaningful time for them to play might be 3 or 4 hours. To you as the parent, it's not going to be that long. You got an hour. Meaningful to me as the parent is 1 hour. That's not meaningful to a child at great estate. To them, it's all day long. So meaningful time is an insult to landlords. The executive order does not violate the plaintiff's rights under the petition clause. Plaintiffs argue that the Executive Order 202-28 denies them their constitutional rights to petition the government because they can no longer file summary proceedings for non-payment of rent or for their tenant's failure to replenish their security. This claim is meritless. And basically what she's saying is that if the eviction moratorium here in New York and probably other states. So we want you in other states to see what happened here in New York, and it may apply to your state as well, so be prepared. What they're basically saying is that since there's no eviction moratorium that's going to go on and on and on and on and on, or that rather that the eviction moratorium is forever, it's not. That there is a time frame that it will end. When that is, right now it's August 19th, but who knows how much longer. Because it's not a definite, permanent eviction moratorium in place, all of their arguments have been dismissed. Because it's not permanent. Well, the debt that the landlord incurs because the tenant will not pay the rent is a permanent debt. Is a permanent harm to their income. Because they still have to pay the property taxes, the upkeep, the regulations, the mortgage, sewer, water, trash, removal, you name it. They have been harmed. The tenants have not. I know this is a very long video. There's a lot to go over here. We want you to look at this, watch the other video, watch this one, see what's going on, see if it applies to your state. We're going to be back again very shortly with another video and many more to follow. So landlords, we want to know your feeling on this. Do you think the eviction moratoriums are right? Is it okay that the government says that they can go on and on and on, and because they can go on and on, that it's not really hurting landlords, that they can eventually get the day in court? Leave your comments below. We want to read them, or we're going to respond. Also, please subscribe to our channel. Watch our videos. Share them with other people. You have our permission. Share them with everyone that you think can be helped by our videos. Again, the landlord advocates are here to help landlords become better landlords. We are advocates for you, landlords. We're here with you. We're here for you all the time. Again, thank you for watching. We wish you the very best. Take care.